Following on this episode of Law Weekly, a chat with Senior Advocate of Nigeria and Queen's Counsel, Professor Fidelis Odita. We talk about the legality of the Muslim ticket of the All Progressive Congress APC, the role of the judiciary in the electoral process, vote buying, and more. Also showing on the program, the Nigerian Bar Association asked the chairman of the body of benchers to recuse himself following allegations of professional misconduct by one of his partners, plus a recap of some of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Shieli. The Muslim presidential ticket of the APC continues to generate reactions, with many arguing rightly that the issue is not about the qualification of both men to contest for office, but whether the move is in conformity with the constitutional principle on federal character. Many say that zoning is a product of federal character, while others argue that religion has nothing to do with federal character. This issue is the starting point of my conversation with Senior Advocate of Nigeria and Queen's Counsel, Professor Fidelis Odita.
I think from a legal point of view, there is perhaps nothing illegal with a Muslim ticket. The law is not a problem. And I don't see that this has anything to do with federal character, because the federal character addresses the federal government, the state governments, and so on. As far as I'm aware, APC is not the federal government. PDP is not the federal government. So it's doubtful whether those provisions apply to them. But that's at the level of law. At the level of fairness, equity, and morality, on the other hand, yes, the political parties are not bound by federal character, but the federal character enshrines an important value to us as a nation. And therefore, we all try to reflect the federal character in the things that we do. And one would expect major national parties to reflect the federal character, irrespective of whether or not the federal character principle in Section 14 is binding on them. So I find the choice of a Muslim ticket under the APC most unfortunate. And I find it really shameful that in the entire North, he could not find a single Christian in APC that could help him win the presidential election. That really says something about his own assessment and about the northern Christians. I mean, some of them say, oh, it doesn't matter, religion, this is politics, it's not about religion. But our politics is very closely intertwined with religion.
I also want to get your comments on the electoral process of especially the last two governorship elections that we saw. That's talking about Ekiti and Osun and the outcome. Let's evaluate the process as a means of strengthening the electoral system, because now we hear about vote buying. What are your thoughts about that one?
Yes, I think in general, one has to be fairly happy with the electoral processes that we saw in Anambra State and more recently in Osun State. And why do I say that? First of all, we have this BVAS, Bimodal Voter Accreditation System, which appears to be working very well. It has solved a major problem, which is the manual accreditation, where people just write up accredit their friends, accredit rats, rabbits, chickens, and then produce fake results. So the BVAS has brought the chickens home to roost. And we saw what it did in Anambra State, where, for example, Mr. Anduba, who claimed that he had over 220,000 votes in the APC primaries, could not get up to 100,000. If only 50% of those delegates who allegedly voted for him to be their candidate had turned up, he would have become the governor. But the difference between their primaries and the actual election was BVAS. People ran away. So also we saw in Osun. I mean, the total number of votes, less than 800,000. And of course, they wanted to do the magic of 2018, inconclusive election. But so the process is good, the BVAS, and also strengthening the legal framework to a degree by saying, well, we only, for purposes of having runoffs, and inconclusive election, we are only interested in those accredited, not those on the register, because clearly those on the register might include my dad who has died, might include my children who have gone away, or they're on holiday, or they're somewhere. The voter register is simply not the point. It's the number of people who presented themselves for voting on the day of election. So to that extent, the process appears to be working reasonably well. And the fact that these results are now transmitted to an INEC server that they now say they have, whether it is in the cloud or wherever it is, it means that we are all armed to access the results real time, which prevents the rigging that one sees from one point, from the point of voting to the point of collation. So to that extent, the system is improving, but the system is not self-executing. The system requires human beings to execute, and that's where this voter buying and minor irregularities arise. Why would there not be voter buying? In America, in the UK, when they were at this comparable point that we are, the people were buying votes. It's all about poverty. The politicians have weaponized poverty. The people have been wholly impoverished. They see nothing of a government, and therefore they see this as the opportunity to get something. It's all very well for us to tell them that if they collect 1,000 or 2,000, they will suffer for the next 4 years. If they don't collect, they will suffer. If they collect, they will suffer. So they have to collect. Of course, we need to do something to stop and to penalize people who pay them, not the people who collect. Because the people who collect are already victims of a system that has weaponized poverty. I don't think, for example, INEC should be given the burden of prosecuting. Come on, what does the police exist for? These are crimes, electoral offenses. Why can't the police prosecute those people? If they have insufficient prosecutors, why can't they appoint additional prosecutors? We don't need to create, to burden INEC with having to prosecute. So INEC is now the electoral umpire. In addition to that, it now becomes an investigator and a prosecutor. No, INEC should provide the evidence of wrongdoing, and then the law enforcement agency should enforce our laws by taking those people to court. But we have seen both, we lack institutional capacity to enforce our laws. And that is why we're having this conversation. If this happened in the UK or in the United States, you'll be sure that they will prosecute them, because those prosecutors have the capacity to take on politicians. But here, when the policeman who should arrest them is carrying the bag with which they are going to bribe, who is going to enforce your laws for you?
Let's also talk about the role of the judiciary, especially in the electoral system. When you recall how the immediate past CJN left office and that infamous letter by 14 justices of the court complaining about the conditions of service at that court and welfare issues and all of that, how can the judiciary win the confidence of Nigerians and the electorate, especially as we're going into election season?
Most people who have engagement with the court will never get to the Supreme Court. The judiciary is about all levels of decision making: the magistrate courts, the customary courts, the area courts, the high courts, the Court of Appeal, and the Supreme Court. So I don't want us to get distracted with the welfare politics of the Supreme Court. And they are complaining about not having diesel or rationing diesel. That is not our problem. The fact that they should even be talking about that is itself disgraceful. You cannot hear the UK Justice of the Supreme Court or the United States Justice of the Supreme Court, to whom they like to benchmark themselves, complaining about such quasi-stomach infrastructure. That's not what it's about. We're talking about a system that has to inspire confidence in the users of that, because the courts are a public resource. And people say the judiciary is the last hope of a common man. I don't know whether people still feel that way. But a system that you want to engage, you must feel some level of confidence in that system. But that's not about the Chief Justice of Nigeria. It's about all the apparatus of dispute resolution through the courts. It's about the judges. It's about the registrars. It's to give people confidence that this system is not completely broken, is not completely corrupt, it will work. In saying that, there are a good number of judges, magistrates, who are doing their best to make this system work. And I know a number of them, and I commend them. But at the same time, there are major, major problems. As I always say, the entire problem we have in Nigeria can be reduced to three things at the level of the courts. First, the lack of institutional capacity, both human and infrastructural. Secondly, the lack of cooperation between the major stakeholders, the litigants themselves, the lawyers, and the judges. And three, the method of appointment of these judges. If you take the first one, the lack of institutional capacity, what is the funding? I'm not even talking about the salaries of the judges. How much do we allocate to the courts? What is the ratio of litigants to judges? If you know any judge that has less than 20,000 cases on his or her docket, you can tell me. So what type of justice system are you going to produce where you give one person 10 or 20,000 cases? When in this life are they going to finish with that? So you have a problem first of lack of capacity. The system simply, there aren't just enough courts to deal with. You can't just have these few people and you give someone 10,000 cases, you give someone 20,000 cases. How are they going to deal with it? They can't. So we need to begin to understand the problems. These the National Assembly and the executive, who do pretty little and take all the money and then give very little to the courts. And then when it gets to their own matter, they make changes to the Constitution and give themselves priority. So in a few months, all we'll be doing is election. And we'll do the elections for 2 years. Everything else we suffer, criminal justice, civil justice, the judges won't even be there. Many of them will say they've gone for tribunal duty. They will adjourn these cases so that you have a complete backlog, because you have a 6 or 9 month period where most judges, not all of them, are on election duty to elect how many people? How many are they? At all levels. So the whole country is beholden to a few people. And they are the ones that allocate the money. And they give very little to the courts. And the little they give to the courts, they complain that the senior judge, the chief justice, has stolen most of it. That's what his mates were complaining. So you have a system that first is inadequate, and the little that they have given them, they've stolen, which is both a problem of ethics, morality, criminality, all wrapped into one. So, and that's why I keep saying, no matter what you do, even if you give them more money, the money is not going to spend itself. People are going to spend it. We've known cases where chief judges or chief judges, when they are retiring, they take monies that are meant for the courts to go and build themselves houses. In this country, nothing has happened to them.
Prof, let's round off talking about the role that the Nigerian Bar Association should be playing. We recently elected new national officers. What can they do to move us forward? I
think, first of all, that the bar should try and reinforce the rule of law, because that is really a watershed concept for everybody. When you have rule of law, to ensure that people are governed by laws. The bar is not, of course, the judges and the legal practitioners are all members of the bar, but that is where we must start. We must, of course, I don't want to call it a trade union, but the NBA is like a trade union, isn't it? Where we're all members, and the first thing that it should do is that it should try to encourage the rule of law. Unfortunately for us, we have had leaders in the past who have been embroiled in all sorts of difficulties. But the NBA can also solve very problem. So they can do rule of law. The NBA can become more active in the selection of judges. They are not in the statutory framework. There's nowhere which gives them a role to play. But as the umbrella association, they are very influential. They can give themselves additional role. And we have to encourage the judges who are there to respect the views of the NBA. In most cases, they're not respected. I saw the current leadership that is going out in August. They tried. And I think, in fairness to them, you say that for the first time, you saw an NBA that was fairly independent, took on active intervention in areas where the NBA should be intervening, and you saw the role they played in the selection of judges and so on. We need that agenda to continue. But beyond that, I don't think NBA has any additional role to play. I hear people in the public say, when this is happening, what should the NBA do? They can come to court as an amicus, as a friend of the court, to present a brief. And perhaps they should do more of that in public interest litigation to reflect the views of the association. Now, this is where the judges might not accept what they're saying, but at least they should do more of that to try and make the NBA. And in order for, of course, to fulfill that role, you have to elect people of integrity and character, because otherwise they become themselves vulnerable to abuse by the system.
Welcome back. We move on now to another topical issue. By a letter dated the 22nd of July, the Nigerian Bar Association NBA has asked the chairman of the body of benchers, Chief Wole Olanipekun, to recuse himself so an interim leadership can be put in place in order to allow the Legal Practitioners Disciplinary Committee, LPDC, investigate an alleged act of professional misconduct by one of his partners.
About a month ago, Ms. Adekunbi Ogunde, a partner in the law firm of Wole Olanipekun & Co., admitted to sending an email to Saipem Contracting Nigeria Limited to solicit for a brief which was being handled by Ajumogobia and Okeke, the law firm of former Minister of State for Petroleum Resources, Senior Advocate of Nigeria, Odein Ajumogobia. The brief is related to the ongoing $130 million case at the River State High Court. In soliciting for the brief, Ogunde wrote to a certain Mr. Sayo Francesco, claiming that her law firm, Wole Olanipekun & Co., would be more influential in helping Saipem avert a potential huge payout to River State government. She would later blame this on exuberance. Her firm also sent out a disclaimer saying that Ogunde's letter was sent out without their instruction, authority, mandate or approval. By a petition dated the 19th of July, the NBA wrote to the disciplinary committee recommending that Ogunde be required to answer for the allegations of professional misconduct. The NBA president swiftly followed up with a call for Chief Olanipekun to step aside as the chairman of the body of benchers to allow for due process and for the LPDC to carry out its duties. The LPDC is a standing committee of the body of benchers whose processes come under the supervision of the chairman of the body. The NBA noted that against the backdrop of its partnership relationship with Ms. Ogunde, Chief Olanipekun has been put in a situation where his continued occupancy of the office would conflict with or be reasonably interpreted to conflict with or influence the process of the disciplinary committee. The NBA therefore asked Chief Olanipekun to take the honorable path of stepping aside in the interest of justice, fairness, and posterity. When contacted for his reaction, Chief Olanipekun via phone said he was on holiday outside the country and had not seen the letter nor received it.
And just before we go, a recap of some of the top trending legal stories in the news.
We begin with the report that the former Accountant General of the Federation, Mr. Ahmed Idris, and his co-defendants have pleaded not guilty to a 14-count charge bordering on stealing and criminal breach of trust to the tune of 109.5 billion naira preferred against them by the Economic and Financial Crimes Commission. The trial judge, Justice Adeyemi Ajayi of the Federal Capital Territory High Court Abuja, also ordered that the defendants be remanded at the Kuje Correctional Facility pending the hearing of their bail application. At the arraignment, the four defendants pleaded not guilty. The defendants' counsel asked the court to maintain the administrative bail granted to his clients by the EFCC since they never breached any of the conditions. The prosecution counsel, Senior Advocate of Nigeria, Rotimi Jacobs, however, objected to the submission of the defendant's counsel, stating that the decision would send a wrong signal to the general public. He added that the defendants only enjoyed the administrative bail when the matter wasn't charged to court, but with the charge preferred against them, bail was now at the discretion of the court. After listening to both parties, the trial judge, Justice Ajayi, ordered that the defendants be remanded in Kuje Correctional Facility pending the hearing of the bail application. She subsequently adjourned the case to July the 27th for hearing of their bail application. At the Federal High Court, also in Abuja, Justice Ian Eko has issued a 7-day ultimatum to a Senior Advocate of Nigeria and leading prosecutor for the EFCC, Mr. Rotimi Jacobs, to show cause why he should not be disqualified from further prosecuting a former governor of Abia State and Senate Chief Whip, Ojus Okalu, in a 7.2 billion naira money laundering charge. Justice Ian Eko made the order while delivering ruling in a motion filed by Rotimi Jacobs' chambers seeking transfer of the trial to Lagos State Division of the court. In the ruling, Justice Eko held that the senior lawyer and his team have engaged in a gross abuse of court process in the manner the prosecution was being handled. The judge dismissed the request to transfer the trial to Lagos on the grounds that it's only the Chief Judge of the Federal High Court, Justice John Soho, who can do so in line with Section 98 of the Administration of Criminal Justice Act 2015. The judge said granting the request will lead to a breach of the Constitution, as well as an attempt to challenge the finality and supremacy of the Supreme Court of Nigeria. The same Justice Ian Eko has permitted a civil society group to apply for an order compelling the Inspector General of Police to prosecute the presidential candidate of the All Progressives Congress, Bola Tinubu, over alleged perjury. Justice Ian Eko held that the ex parte application was meritorious and subsequently granted it. The ex parte application was filed by the group following the alleged refusal of the Inspector General of Police, Usman Alkali Baba, to arrest and prosecute the former Lagos State Governor for supplying false information on oath in respect of his educational qualifications. Staying with politics, the presidential candidate of the Labour Party, Peter Obi, is asking the Federal High Court in Abuja to dismiss a suit seeking his disqualification for nominating his campaign manager, Doyin Okupe, as his placeholder. Last week, the People's Democratic Party had asked the court to bar Obi from replacing Okupe as his running mate. The PDP had also asked the court to prevent the All Progressives Congress presidential candidate Bola Tinubu from replacing Kabiru Masari as his running mate, but the party candidates nominated Yusuf Baba Ahmed and Kashim Shettima as running mates. Responding to the originating motion, counsel to Obi and Okupe asked the court to dismiss the request of the PDP on the grounds that it is speculative and devoid of hard facts. The suspended Deputy Commissioner of Police, DCP Abba Kyari, has been testifying about his experience during the July 5th Kuje Correctional Facility jailbreak by insurgents in Abuja. Before Justice Emeka Nwite of the Federal High Court Abuja, Kyari, through his counsel, Mr. Onyechi Ikpeazu, said that though the terrorists had opened all the gates and forced all inmates to escape, he, along with 4 other members of the Police Intelligence Response Team that were also remanded with him, declined to flee. Aside his trial, he is asking the courts to grant his fresh application for bail on the grounds that the Kuje jailbreak has established an exceptional circumstance that should warrant the court to release him and his men on bail, pending determination of the charge preferred against him by the NDLEA, as they have shown that they will not jump bail. On its part, the NDLEA asked the court to refuse the defendant's fresh application for bail on the grounds that there was no evidence to prove that they were being confined with criminals at the correctional facility. Justice Emeka Nwite has adjourned the case to August the 30th for the ruling on Abba Kyari's fresh application for bail. And we round off with the report that the Federal High Court sitting in Abakaliki, Ebonyi State has disqualified the governor of the state, Dave Umahi, from contesting the senatorial election as the candidate of the All Progressives Congress in the 2023 general elections. The court also disqualified the governor's younger brother, Austin Umahi, from taking part as a candidate in the forthcoming elections. The lead counsel to Anne Agom Eze, Barrister Nnemeka Nwonu, told Channels Television that a judgment delivered by Justice Fatun Riemann cited Section 115 of the Electoral Act, which forbids a person from contesting 2 different primary elections in the same year. The presiding judge therefore declared that the authentic candidate of the APC for Ebonyi South Senatorial District is Anne Agom Eze, as the earlier winner of the contest, Austin Umahi, had withdrawn from the race. Meanwhile, in a swift reaction, the Special Assistant to Governor Umahi on Strategy, Chris Oko, said the judge was misled by Anagom Eze, who lied on oath that she never withdrew from the contest.
And that's the program this week. Please feel free to share your thoughts on any of the content we featured today. If you missed any part of it, you can find the video and past episodes on our YouTube channel. I'm Shola Shoyele. Thank you for watching and see you next time.